What if the decision you made to protect your family's home, the one that felt responsible and loving, actually set you up for one of the worst financial outcomes of your retirement? That is happening to real families right now, and most of them never saw it coming. If you are thinking about signing your house over to your kids, please stop and watch this first. What I'm about to share could save your family $66,000 to $82,000 or more. If this is the kind of information you need, real answers about retirement finances explained in plain language, subscribe to Informer John on YouTube right now. We cover what actually matters to your life and your money. Now, let me tell you why this conversation keeps coming up more and more, especially in 2026. If you turn 65 today, you have close to a 70% chance of eventually needing some form of long-term care. Think about that number for a second. That is nearly 7 out of 10 people. And care is not cheap. A nursing home now runs about $8,000 to $10,000 every single month. Assisted living, which many people assume is a manageable step, costs $4,500 to $6,000 a month. Medicare does not cover long-term custodial nursing home care beyond a short rehabilitation window. So for most people who end up needing that kind of care, Medicaid is the only realistic option. But to qualify, you generally have to spend your assets down first. And for most families, the home is by far the biggest asset they own. That combination, expensive care, limited coverage, and a house sitting as the largest target, is what pushes people toward gifting the home to their children. And it is also what makes getting this wrong so costly. Let me tell you about Robert, 74 years old, retired engineer from Ohio. He was worried about nursing home costs eating through everything he had spent his life building. A neighbor, not an elder law attorney, just a neighbor, suggested he put the house in his daughter's name. It seemed simple. She was happy to help. Robert kept living there, and for a while, everything felt settled. Then, 2 years later, his daughter went through a divorce. Suddenly, the house, Robert's house, the one he had lived in for decades, was legally an asset in divorce proceedings. Robert had no legal standing. He could not stop what was happening. A few years after that, when Robert's health declined and he applied for Medicaid, the state looked back at his recent financial history. Federal rules require every state to review all asset transfers made within 5 years of a Medicaid application. The transfer showed up. The state calculated a penalty period of ineligibility based on the value of what he had given away. Robert had transferred his home, lost control of it to a divorce proceeding, and still ended up without Medicaid protection. He got the worst of every possible outcome all at once. His story captures all three of the risks most people are never clearly warned about. The first is loss of control. The moment that title changes to your child's name, the house belongs to them, completely and legally. They can sell it without asking you. They can borrow against it. If they face a divorce, a bankruptcy, a lawsuit, or a creditor judgment, that property is exposed. You go from being the owner to depending on goodwill. And here is the hard truth. No matter how much you trust your child, goodwill is not a legal right. Life brings pressures nobody anticipates. Marriages end, finances collapse. The person who was completely trustworthy yesterday can be facing circumstances tomorrow that change everything. The second risk is that the Medicaid protection you thought you were buying often does not actually exist. And the 5-year look-back rule is why. Every state under federal law must examine asset transfers made in the 5 years before a Medicaid application. If you gifted your home to your children at any point within that window, the state treats it as deliberate deprivation of assets. They calculate a penalty period of ineligibility based on the home's value divided by the average monthly nursing home cost in your state. During that penalty period, Medicaid will not pay, even though you no longer own the home. You gave it away. You still have to cover your own care. The protection you thought you built was never there. And there is no hiding this. Medicaid applications require complete financial disclosure. The transfer shows up. the penalty follows. The third risk is the one that gets mentioned least, and in pure dollar terms, it may be the most expensive of the three. When you gift your home to your children while you are alive, they inherit your original purchase price as what the tax code calls a carryover basis. Here is what that actually means in real numbers. Say you bought your home in 1988 for $120,000, and today it is worth $450,000. You gift it to your children. Their tax basis in that house is $120,000, your original cost. When they sell it for $450,000, they owe capital gains tax on $330,000 in profit. At combined federal and state rates, that can reach 20 to 25%, depending on your state. That is $66,000 to $82,000 in taxes your children will owe on a gain that could have been completely wiped out with a different approach. Most people are never told about this because the ones advising them to gift the house are not tax attorneys. Now, here is what that different approach actually looks like. If instead of gifting the home while you are alive, you leave it to your children through a will or a properly structured trust, they receive what is called a stepped-up basis. The home's fair market value at the time of your death becomes their new starting point for capital gains. If the home is worth $450,000 when you pass away, and they sell it shortly after for $450,000, there is zero capital gains tax owed. The entire appreciation you built over your lifetime is permanently erased for tax purposes at death. That is $66,000 to $82,000 your family keeps, simply by not gifting the house while you are still alive. So if gifting is such a minefield, what should you do instead? Let me walk you through the real options. For a lot of families, the right answer is a transfer on death deed. As of 2026, it is available in more than 30 states. This deed lets you name your children as beneficiaries directly on the property title. You keep full ownership and full control for the rest of your life. You can revoke it or change the beneficiary at any time. When you pass away, the property transfers to your children automatically. No probate, no court involvement, no waiting period. And here is what makes it so powerful. They receive a stepped-up basis, which eliminates the capital gains problem entirely. Recording the deed with your county costs $20 to $50, and in most states does not require an attorney. If your state offers it, this one tool solves the probate issue without creating any of the risks that come with gifting. For families where Medicaid planning is the primary concern, there is a different tool, the Irrevocable Medicaid Asset Protection Trust, sometimes called a Medicaid trust. This is a trust built specifically for this situation. You transfer the home into the trust, but you keep the legal right to live there for the rest of your life. The trust owns the house, not your children directly. That means the divorce risk, the lawsuit risk, and the creditor exposure that come with an outright gift simply do not apply. Your children cannot sell the home or pull equity from it without going through the trust administration process. And because you have given up ownership through an irrevocable structure, if you set it up at least 5 years before applying for Medicaid, the home is protected from the nursing home spend down. Now here is the part that makes the Medicaid trust significantly better than a direct gift on the tax side as well. Because you retain the right to live in the home, what is called a life estate, the property still receives a stepped-up basis when you die. Your children avoid the carryover basis trap entirely. They get Medicaid protection and the full tax benefit at the same time. Everything a direct gift was supposed to accomplish, a Medicaid trust can accomplish without loss of control, without divorce and creditor exposure, and without the capital gains consequence. What about families with larger estates? The federal estate tax exemption in 2026 is $15 million per individual. That threshold was raised permanently by the One Big Beautiful Bill Act signed in 2025. For the vast majority of American families, federal estate tax is simply not a concern. A well-drafted will that leaves the home directly to your children, combined with a transfer on death deed if your state allows it, handles the probate issue and preserves the stepped-up basis without requiring any transfer during your lifetime. One more thing worth knowing because it catches people completely off guard. If you gift your home but continue living there without paying your children fair market rent, since they now legally own it, the IRS may treat that as an incomplete gift. That means the property could still be considered part of your taxable estate anyway. So you gave away control of your home, created every one of the risks we just talked about, and may not have accomplished a single estate planning benefit in the process. Here is the bottom line. Signing your home over to your children, whether to protect against nursing home costs or to avoid probate, is one of the most common and most frequently regretted financial decisions being made right now. The three risks are real. You lose control the moment the title changes. The 5-year Medicaid look-back rule can leave you paying for nursing home care you thought you were protected from. And the carryover basis tax consequence can cost your children tens of thousands of dollars in capital gains tax that would have been zero if they had inherited the home rather than received it as a gift. A transfer on death deed, available in most states, solves the probate problem while keeping you in full control and preserving the stepped-up basis. A Medicaid irrevocable trust, established at least 5 years before you need care, addresses both the Medicaid and the probate concern while protecting the tax advantage. And for most families with estates below $15 million, a properly drafted will alone, leaving the home to your children at death, achieves everything you are trying to accomplish without any transfer during your lifetime. The planning that actually works gets done before a crisis forces your hand. If you are seriously thinking about transferring your home, please sit down with an elder law attorney in your state before you take any action. 1 hour of professional advice costs a fraction of what it costs to get this wrong. Share this with someone in your life who is facing the same decision. It could make a real difference for their family. And subscribe to Informer John on YouTube for more videos like this one. I will see you in the next one.